All right, thank you guys. You can be seated. Have people been in this courtroom before? Is this where the judge sits? Okay, excellent. Thank you. We are still waiting on a juror who will be with us in just a minute. So you can talk amongst yourselves, and then once she joins us, we can get started. While we wait, our jurors can confirm that they don't have any conflicts with the competitors.
No conflicts.
Excellent. Okay, I think I am supposed to have a copy of the exhibits. I don't. Do the parties happen to have a spare? Otherwise...
We do, I think, everything's in here.
Okay, is that something that you will need for...
No, we'll be fine with that.
Okay, great.
May I approach?
Yes, you may. Thank you very much.
No problem.
Okay, why don't we go ahead and get started. I will hear appearances from the parties.
Good afternoon, Your Honor.
Good afternoon.
Charles Stock for the plaintiff, joined by co-counsel Nolan Reddy.
Good afternoon, Your Honor. Before we get started,
Yes.
can we do a conflicts check fully? I don't know if I missed that.
Your Honor, I think we might have one conflict.
Okay.
Yeah, because she was the witness in the last round that he and I, well, her two, we judged.
That is not a conflict for the purposes of this tournament. Yeah. Appreciate you flagging that issue, but I think that you can see the same competitor in a different role without it being a conflict.
Okay.
Yeah.
Thank you.
Thank you to the folks who called that out, though. Can I hear your names again real quick? I'm sorry.
Charles Stock and Nolan Reddy.
Perfect. Thank you.
Good afternoon. Ethan Marx on behalf of the defendant, Dragon Studios,
Good afternoon.
represented in court today by Ms. Cole Doig.
Good afternoon.
Good afternoon. So am I right that this is the Stock v. Marx trial?
That is correct, Your Honor.
Okay, perfect. Thank you for those appearances. Are there any housekeeping matters that the parties wish to raise with the bench now?
Yes, Your Honor. If I could direct your attention to the pretrial order form within that notebook there, number 9.
That may be one of the documents I don't have.
I could summarize.
Okay, sure.
The court has ruled that all non-testifying witnesses in this case are deemed unavailable. Do we have permission to have my co-counsel actually take the witness stand to read off portions of the deposition answers when we're reading the depositions?
Why don't we do this? If that is deemed admissible, there may be other evidentiary issues, then we can have it done that way. But we'll take it on an as-needed basis.
Absolutely. Also on that pretrial order form, number 6 says that exhibits 1 through 25, those are all pre-admitted.
Okay, and is that your understanding as well?
It is.
Okay.
We'd ask for constructive sidebars, all objections heard outside the earshot of the jury.
Absolutely.
And we'd ask for your preferences about moving about the well.
Sure. So that's going to be the witness stand. Do not approach the witness without permission. If you're going to publish something to the jury, ask for permission, but you can make use of this area right in front of the bench without asking for permission again.
Great, that's it from us.
Okay, great. Any housekeeping matters for the defense?
Yes, Your Honor. We move to invoke Rules 615 and 603, calling for the constructive sequestration of all witnesses and the constructive swearing in of all witnesses.
Great. That will be done, and I imagine that Ms. Doig is going to remain with us in the courtroom.
That's correct. She's our party representative.
Perfect. Any other housekeeping matters?
Yes, just one more thing. Per the rules of this jurisdiction, we have to tender a verdict form pursuant to which affirmative defenses we are bringing. We're bringing verdict form D. We're not bringing any affirmative defenses today. May I approach?
Yes. Thank you.
You're welcome.
There's nothing else from us. We're ready for openings.
Okay, no substantive matters from the parties?
None?
Great.
Your Honor.
Plaintiff's counsel, you can begin opening when you're ready.
Please, court. The original plan was dangerous. The defendant's plan was deadly. It's a warm summer night. On the set of the defendant's next blockbuster movie. It is a celebration. For months, they've been planning, practicing run after run, and the star of the show just pulled off the most daring stunt in cinema history. 6 times in a row. Everyone's happy. Everyone's relieved to be done. Everyone except for one person. The producer. Instead of partying, she's planning. Members of the jury, this is Peter Jones. This is that movie star. You'll learn this man got caught up in the defendant's plan. Because what you're going to learn is that when that producer looked at the film from that stunt, she wasn't satisfied. She thought to herself, that's just not good enough. That shot, it's just not long enough. So she took it upon herself to make a new plan. And the first time that plan was used, you'll learn that's when Peter Jones died. The original plan was dangerous. The defendant's plan was deadly. That's why Peter Jones's estate has brought a suit of wrongful death against the defendant, Dragon Studios. They have to prove, more likely than not, that they acted unreasonably, negligently, carelessly, and that their actions caused Peter Jones to die. We're going to meet that burden today. For 3 reasons. The producer made her own plan. She wasn't honest about that plan. That plan caused Peter Jones to die. So let's take those one at a time, starting with the first. The producer made her own plan. You're actually going to see a video of the stunt that Peter Jones pulled off successfully. And even with the original plan, it's going to look pretty crazy. You'll see that the guy rides a motorcycle off of a cliff into a free fall, and then gets a signal from the producer, pull your parachute. Pulls the parachute, and everything's okay. That was the original plan. Then you'll learn the producer looked at the footage from those successful stunts but the shot's just not long enough. It's just not good enough for what I want in my movie. Let's film it again. This time, I'm not going to give the signal to pull the parachute. How did you convince people to do that? That's fact number 2. The producer wasn't honest about her plan. Members of the jury, you're going to learn the producer. She went to the stunt coordinator, and she pitched it a little bit different. Hey, what if I only wait a little bit longer before giving the signal to pull the parachute? Would that be okay? The stunt coordinator's response? Absolutely not. You'll learn the producer didn't take no for an answer. She went up to the plaintiff anyway. Stunt coordinator says it's fine. Trust me. It'll be safe. The plaintiff trusted her. The plaintiff died. That brings us to fact number 3. That plan is what caused the plaintiff's death. Members of the jury, what you're looking at now are the last few seconds of Peter Jones's life. Falling. Waiting to hear in that earpiece what he'd been promised. That signal, pull your parachute. You'll learn that signal never came. He had to pull the chute on his own. And by the time he did, it was too late. Members of the jury, that first plan, it was dangerous. But the defendant's plan, that made it deadly. That's why at the end of this trial, we're going to ask you to find the defendant lying. Thank you.
Thank you, counsel. Do we have an opening from defense counsel?
Yes, Your Honor. May I proceed?
You may.
Thank you.
Counsel, I'm so sorry to interrupt.
You're good.
It looks like my exhibit binder's here,
Oh, perfect.
and I didn't want you to have to worry about that in the middle of your opening. Thank you.
No problem.
All right, counsel, you can begin when you're ready.
They lost connection, and Mr. Jones lost his life. Members of the jury, no one is going to stand up here and tell you that what happened to Mr. Jones wasn't a tragedy. It was. And because his death was so painful, it's natural to want to find someone, anyone, to blame. Now today, the plaintiff, they just told you who they want you to blame. They want you to see that because Mr. Jones died on the set of the movie, well, it must be the fault of the person who was producing it. That their plan must have been deadly. But today we're going to ask you to consider a different version of events. You're going to hear that, yes, Ms. Doig, the producer of that film, well, she did have a plan for that stunt. You're going to hear that, yes, that plan, it was different from the original one that they had made. What you're going to learn today is that Ms. Doig had that plan approved, both by Mr. Jones and by the stunt coordinator on their own team. A few moments ago, Mr. Stock told you that, well, that plan, it had Mr. Jones waiting too long before he would deploy that parachute, told you that Ms. Doig wasn't honest about that plan. That she never told Mr. Jones, gave Mr. Jones the signal to release that parachute. But today you're going to hear that she made that plan because she thought it was going to be safe, thought it would be reasonable. That on the day before that plan, she talked about it with Mr. Jones and that she was honest with him, that he agreed. You're going to see that on the day Mr. Jones died, she followed that plan. So you might be wondering, well, then, how did we end up here? Today you're going to hear that the reason Mr. Jones got hurt, well, it wasn't because she failed to follow that plan or failed to follow safety standards. Now, today you're going to see that every time Mr. Jones ran that stunt, he had an earpiece in his ear. That's how we would get the signal from the producer to pull the parachute. But you're going to hear that when Miss Doig was giving that signal to Mr. Jones, he wasn't responding. You're going to hear that this earpiece lost connection, and that is why Mr. Jones lost his life. Now, before I go further, I want to make one thing very clear. Only one side had the burden of proving what actually happened in this case, and it wasn't us. Now, today you're going to hear that it is the plaintiff's job, and the plaintiff's job alone, to prove that it was actually Miss Doig's studio's actions that caused Mr. Jones' death. But they're not going to be able to do that today. And to help you see why, we're going to ask you to keep 3 questions in mind as you listen to the evidence. First, what is the plaintiff asking you to believe? Second, how much evidence do they really have? And third, what actually happened on the day Mr. Jones died? So first, what is the plaintiff asking you to believe? Because today they're going to ask you to believe that Miss Doig sat and watched as the lead actor in her movie franchise fell thousands of feet. That she watched, did nothing that entire time. So we're going to ask you to think about whether it actually makes sense for a producer to risk everything for one shot, the risk of destroying the entire film series. Which is going to bring us to that second question, well, how much evidence do they really have? Because like we told you a few moments ago, today it's going to be their job to prove that it was actually Miss Doig who failed to give the signal to Mr. Jones, and that caused his death. So during this trial, we're going to ask you to pay attention to whether or not they can actually confirm that that headpiece was working, and that Miss Doig didn't give the signal that day. We expect that the evidence is going to show that they can't prove that. That Miss Doig did give the signal. Which is going to bring us to that third and final question. What actually happened on the day Mr. Jones died? Well, today you're going to get a chance to meet Miss Doig. She's been a producer here in LA for years. She's going to tell you that she had worked with Mr. Jones for almost a decade. And if she thought something bad could happen to him, something this dangerous, something deadly, she never would have run that stunt. She's going to take that stand and tell that she gave the signal to release that parachute, but no matter how many times she tried, how many times she shouted into her receiver, Mr. Jones didn't release it. Members of the jury, no one is going to ask you to take the sympathy you're going to feel for Mr. Jones and his family and put it on the back burner, because to do that would be near impossible. What we are going to ask you to do is stop short of confusing tragedy with liability. Today it will be your job to ask the tough questions, to hold the plaintiff to their burden. And when you do, we're confident that you'll see Mr. Jones lost his life because they lost connection. We'll ask that you find the defendant not liable. Thank you.
Thank you, counsel. Mr. Marks, before you head back, I'm going to hand you this.
Thank you.
Thank you. Okay, do we have any witnesses from the plaintiff?
We do, Your Honor. Plaintiff calls Eli Gogian.
Right.
You proceed.
You may.
Please introduce yourself to the members of the jury.
Good afternoon. My name is Eli Govian.
What do you do for a living?
I'm a talent agent. That means I represent actors and actresses in their negotiations with movie studios.
How long you been a talent agent?
So, 2006, I'd say. I've been in LA a long time.
I'm holding up pre-admitted Exhibit 3. Do you recognize this person?
That's Peter Jones. Peter, he was one of our actors and actually one of my close friends.
What kind of movies did you work with Peter on?
Peter was the star of this big action movie franchise called All Lost. He would play this sort of James Bond type hero. He'd do these crazy stunts. He did it for Dragon Studios.
Let's talk about why we're here. Were you there for the filming of the last All Lost movie, All Lost 7?
I was. I actually helped Peter negotiate the contract for the movie, and I was in the control tower the day he died.
How was that movie supposed to start?
Well, we had this big stunt planned. But what would happen was Peter would go down a ramp, do a motorcycle jump, let go of the motorcycle, and then skydive down. That's what was supposed to happen.
Let's watch that in action. Approaching the witness with pre-admitted Exhibit 1, a video of the stunt. If you could just angle it like this so that both yourself and the members of the jury can see. Let's hit play. So as the video plays, tell us what we're looking at.
This is the ramp we built for Peter, and there's the jump. He lets go of the motorcycle and begins a free fall. He'd do it for a few seconds, then get a signal in his ear to pull the cord for his parachute.
It's that blue thing right there.
That's the parachute, or that was the parachute. It was a canopy parachute. If it fills with air fast enough, then everything's supposed to be fine.
Let's talk about the plan for that original stunt. Approaching the witness with a copy of Exhibit 34.
You may.
Your Honor, would you like a copy of this exhibit?
No, I've got this.
Do you recognize this?
Yes, this is the stunt plan that I prepared with Dragon Studios and with Peter.
Look to be changed or altered since you last seen it?
No.
Whose signatures are there on the bottom?
Well, there's Peter's, there's mine, Cole Doig's. Cole is a producer for Dragon Studios, she owns it, and then Sky Stebbins. Sky is our stunt coordinator.
Plaintiff offers Exhibit 34.
Any objections?
Yes, Your Honor, under Rule 702 to an improper expert opinion, you actually look at the last bullet point on this document. It talks about industry standards for skydiving. That's an expert opinion that's being offered within this document. We haven't heard any foundation as to who's offering that opinion specifically among the names here, what their qualifications are to do that, and absent that foundation, this document's inadmissible.
Do you have a response, counsel?
We're fine redacting that portion. We won't even be using it.
Just that sentence?
Yes, Your Honor.
Okay, and is that what counsel
Yes, we
requests to be
redact
redacted?
the first sentence of that last bullet point.
Okay, Exhibit 34 will be received into evidence with the first sentence of the last bullet point redacted.
Yes, Your Honor.
So, according to the terms of this original plan, who is supposed to radio in and say, pull the parachute?
It was supposed to be Sky, Cole, or other members of the people on the production team who are in our control tower.
How long were they supposed to wait between the moment the bike leaves that ramp and radioing in?
According to this plan, 4 seconds.
Did this plan work?
Well, I mean, you saw the stunt. We followed this plan 6 times, and for 6 times everything was fine. Everything was good.
Did the defendant's producer say anything about the film from those 6 successful stunts?
Yeah. I thought we were done, to be honest. We got the takes. But that night, Cole, she brought us into the room, me, Peter, and Cole, and she said we needed something longer, something more substantial.
Did she say what that something more substantial would be?
What she told us was that she would signal for Mr. Jones to deploy his parachute after 9 seconds. That's what she told us that evening.
How did Mr. Jones respond?
I mean, he was a little hesitant. It's 9 seconds of free falling, but he asked her if Sky had okayed it, and she said she had, so he agreed.
Let's talk about how the defendant's plan went. Approaching the witness with Exhibit 2, if we could flip the video just from Exhibit 1 to Exhibit 2. What is that video?
I mean, if this is what I think it is, this is the video of Peter's last stunt.
Let's hit play. Pausing here. Where were you at this point in time?
I was in our control tower, and I was watching what was happening on a screen just like this one, watching to see if everything was okay, to see if Peter was okay, to see if his parachute deployed okay, to make sure that nothing went wrong.
Who was there with you?
Cole and I were the two people in the control room.
Who was holding the radio?
Cole was.
Let's keep playing. Let's go 9 seconds after that bike leaves the ramp. Let's stop at 15 seconds. At this point in time, what's happening in the control room?
So this is the moment, right? This is the moment when Cole told me she would send a signal to Peter and say, pull your parachute. And she says nothing. I leaned over and I told her, tell him to deploy your parachute, tell him to pull, and she leaned back and she just raised up her hand. That's it.
Did she ever turn on that microphone?
After a few more seconds, when Cole is, I don't know, 500 feet above the ground, she flicks it on and still doesn't sing.
Did you ask the producer why she didn't give that signal?
Of course I did. I mean, Peter was my friend. And so I asked her, why did you not signal at 9 seconds? I asked her that point blank.
What was her reason?
She was silent. But when I asked her, how could you do this? She said, I just wanted a longer take. That's what she told me.
Thank you, sir. Nothing further.
Thank you, counsel. Do we want to leave those up with the witness?
Permission to publish 34, and we'll take the tablet back to counsel table.
Sure. You can approach and get the tablet and publish 34. Cross-examination?
Yes, Your Honor. Good afternoon, sir.
Good afternoon.
I'm going to ask you a few more questions and then we're trying to get you out of here, okay?
I understand.
Sir, I want to pick up right where you left off a few moments ago. You told us that you were in the control room on the day Mr. Jones passed away, right?
That's right.
You were in that control room with Miss Doig.
Yes.
To be very clear, sir, you and Miss Doig, you were the only people in that room, right?
Yes.
Weren't any other crew members who were there who can say whether or not Miss Doig actually sent that signal?
It was just us. That's right.
Yes, sir, you were on a movie set, right?
That's right.
Even though you're on a movie set, there's not any video recording that you're aware of from inside that control room.
No,
No audio recording.
that's true.
Certainly haven't seen a transcript of what was said on any of the walkie-talkies or radios coming in and out of that control room.
No, I haven't seen any transcripts.
So today, the only evidence you have that Ms. Doig didn't send that signal is your word, right?
Yes.
Then, sir, I want to talk about why you're testifying here today. Because like you've said, Mr. Jones was your client, right?
He was my client, yes. He was also a friend.
That's right, sir. He was actually your first client.
That's true.
You met him right when you moved to LA.
Yes.
Sir, he's a pretty good client to have as your first client, wasn't he?
Yeah, in more ways than one. I mean, he was a movie star, and also he was Peter. I mean, he was great.
Right, he was an important figure in your life, right?
Absolutely.
Together, you and Mr. Jones, you made millions of dollars, didn't you?
Yes,
You considered him a close friend, isn't that right?
absolutely.
You knew his family.
I did, yes.
Today you're testifying here on their behalf, aren't you?
That's true.
Today you want to make sure that there's justice done for Mr. Jones, isn't that right?
Yes.
Well, and sir, I want to talk about whether it would actually make sense for Miss Doig to risk Mr. Jones' life. Because, sir, you'd agree with me, Miss Doig, she had worked with Mr. Jones for almost a decade, hadn't she?
Yes. Cole, me, and Peter, we worked together for that long.
Right, you worked together for a good bit of time.
Yes, that's true.
6 different movies,
Yes,
huge franchise.
that's right. We made the All Lost series together.
That's right, sir, and about 2 years ago, you decided you were going to make a 7th one of those movies, didn't you?
Correct.
So you'd agree with me that Miss Doig and her studio, they put a lot of time, money, and energy into the making of that movie, didn't they?
I'd say so.
So I want to talk about some of the things that they did. I'm handing the witness a copy of Exhibits 10 and Exhibit 14. May I approach?
You may.
Showing Exhibit 10. Sir, they built an entire practice set, didn't they?
Yes, this was out in Ontario, California. We built a practice set to model what Peter had to do. And
That's right, sir. There was a giant ramp that they had built.
that's right.
There's a crane.
Yes.
It's a whole stunt team, wasn't there?
Yes, that's true.
Showing Exhibit 14. They even had a high-tech computer software that they used to track Mr. Jones's movements, right?
Yes.
They practiced hundreds and hundreds of times, didn't they?
Correct.
They had a whole stunt crew there.
That's true.
And so they flew that entire crew out to Norway.
Yes. That's where we have the final shot.
They built a house,
That's right.
built that same ramp.
Yes.
So they invested all of this time, money, and energy for just one stunt, didn't they?
That's right.
So you agree with me that if Mr. Jones got hurt during that stunt, all of the time, money, and energy spent by Miss Doig and her studio will go to waste.
Yes, that's true.
Thank you, sir. No further questions. May I approach and retrieve the evidence?
Thank you. Yes, you may.
If we could actually use the evidence that opposing counsel just used for redirect examination.
Do you want both exhibits?
Yes.
Okay. Why don't we leave those up there with the witness?
If I could grab those exhibits.
You may approach, yes.
May I proceed?
Yes.
This ramp that was built, with which stunt plan was it built in mind?
The stunt plan that I talked about a few moments ago, it's all part of this damn stunt.
The 4-second plan or the never give the signal?
The 4-second plan.
What about these calculations?
The 4-second plan.
Nothing further.
Thank you, counsel. May this witness be excused?
There's no recross, Your Honor. We just have to publish Exhibits 10 and 14.
Yes, you may. Thank you. Thank you. May I step down? Anything further from plaintiff?
Can we get a time check?
Sure. I will turn to our friends over here, yeah.
Yes, 38 seconds left to case in chief.
Okay, nothing further from us, we rest.
Thank you. Does the defense wish to put on a case?
You. Defense calls Cole Doig. May I proceed?
You may.
Good afternoon.
Good afternoon.
Could you go ahead and introduce yourself to the jury?
Good afternoon. My name is Cole Doig.
Where are you from, ma'am?
I'm originally from New Zealand, but I moved to Los Angeles to get into the filmmaking industry.
What exactly did you do in the filmmaking industry?
I am a writer, director, producer, and I own my own studio, Regan Studio.
Ma'am, do you understand that you and your studio have been accused of causing the death of one of your actors, Peter Jones?
Yes, I understand.
Ma'am, did you create a new plan for that movie you were working on?
That's true. We created a new plan, but we made sure that it was safe. We checked over it.
Were you honest about that plan to Mr. Jones and the rest of the crew?
Of course, we told him everything.
Did you ask Mr. Jones to perform a stunt you thought could be deadly?
I would never do that to Peter. Never.
Right, then I want to talk a little bit about that stunt. Whose idea was it?
Peter originally came up with the idea himself. He wanted to go off the side of a mountain on a motorcycle.
And could you describe exactly what his idea for that plan was to the jury?
So he would go down the side, go off of a ramp, then he would free fall and then deploy a parachute and land on the ground.
After Mr. Jones proposed that plan, did you bring in a stunt coordinator to oversee it?
Of course, we brought in an elite company for our stunt crew to design the stunt to make sure that it was safe for them to do.
What sort of things did you ask that stunt crew to do?
We had them do calculations to show the trajectory of Peter free falling. They put trackers on him so that we could measure his altitude. They designed a stunt plan that would show everything that Peter was supposed to do.
Now, did you have Mr. Jones practice that plan before you started filming?
Absolutely. We had him practice it hundreds of times.
Right, so then we've talked about the preparation you took leading up to filming. I want to move to talk about filming. When did you start?
We started the film date on June 20th, 2023.
And did Mr. Jones successfully complete that stunt on the 20th?
He did 6 times.
After he completed it those 6 times, did you ask him to do it again?
We did. I wanted another shot because the original take that we had done, they just didn't get the footage that we quite needed. So I asked him to do it the next day.
Did you suggest any changes to that plan?
Just about everything was going to be the same, the ramp, the mountain, the motorcycle. The only thing that was different was that he was going to deploy his parachute a few seconds later.
And were you going to have a role in that plan?
Yes, just like the day before, I was going to tell him when to deploy that parachute.
And how were you going to tell him that?
Peter had an earpiece that he was wearing as he jumped off of the mountain. I had a radio that would go to that earpiece so that he could hear me give the signal to deploy.
Would you recognize that earpiece if I showed it to you?
I would.
Your Honor, may I approach the witness with what's been pre-admitted as Exhibit 4?
You may.
Handing to the witness. Ms. Doig, do you recognize what I just handed you?
I do. This is the earpiece that Peter was wearing.
And then where were you going to be when you communicated with him with that earpiece?
I was in our control room, which was a room that we had set up with monitors so that we could see everything that was being filmed and watch as Peter went off the side of the mountain.
Ms. Doig, we've heard a lot about this new plan today. I want to be clear, did you think that new plan was safe?
Of course. I only suggested it because I had checked the calculations and I had talked to our stunt coordinator about it.
And then I want to talk about what happened on the day Mr. Jones passed away. How did that day start for you?
We went out to location, just as we had discussed. Peter set up on the top of the mountain. He went down on his stunt, just as he had done the day before, and he went off the side.
Then were you here in court when Mr. Gogian testified?
I was.
Did you hear him say that you never sent a signal to Mr. Jones's earpiece?
I heard that, but that's not true. I absolutely sent that signal to Peter.
So, ma'am, after Mr. Jones took off up that ramp, what did you do?
I was in the control room, I was watching the screen, I watched it tick up to the 9 seconds that we had agreed upon, and I radioed him. I told him to pull his cord.
After you told him to pull the cord of his parachute, what happened?
Peter didn't pull the cord, I was watching as he was falling, so I radioed him again. I said, deploy, 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 and he still wasn't reaching for his cord.
Did he ever pull the cord on that parachute?
He did, but far too late, and he was going much too fast.
What happened?
Mr. Goudion and I, we were in the control room, and we watched on the monitor as Peter crashed into the ground.
Thank you, ma'am. Your Honor, I have no further questions.
Thank you, counsel. Cross-examination?
Yes, Your Honor. May I retrieve Exhibit 4?
You may.
May I proceed?
Yes.
Start by talking about this earpiece. This earpiece was always Peter's earpiece.
That's correct.
Didn't change out the earpiece to a new one.
No?
In those hundreds of practice runs you did, never a problem with this earpiece.
Well, Peter was wearing it for the day before on the actual day of filming on June 20th. We did 6 practice runs.
I'm talking about the hundreds prior in preparation. Earpiece A-OK.
That's correct.
June 20th. Those 6 stunts went off without a hitch.
That's right.
Let's talk about whether we should be believing you when you say, I did give the signal. Ma'am, you've lied about what happened the day Peter Jones died before.
That's not correct.
Let's
No.
talk about it. You were there at the scene when Peter Jones died.
Yes.
You were surrounded by the crew.
Yes.
Your attorneys asked you about that situation.
They did.
They asked you, what did you say to them?
That's correct.
You said, I don't remember what I said to them.
I said that I was emotional at that time, and I was.
The words you used, ma'am, were, I don't remember.
I don't remember I was emotional. That's correct.
That wasn't true.
I mean, I eventually remembered some of what was being said, but it's true. I had watched Peter fall to the ground there.
Ma'am, you remembered word for word what you said after our attorneys threatened to depose the people at the scene with you.
I know what I said afterwards, but I was emotional at the time. I just remember seeing Peter there.
That's a yes.
Yes.
Those people at the scene asked you, why didn't you give the signal?
That's correct. Mr. Goudion said that.
They asked you, how could you do this?
That's what he asked me.
And then you remembered that you said, I wanted a longer shot.
I said that I thought I had more time. The calculation showed that we would have enough time.
You said you wanted a longer shot.
I said I wanted a longer shot. I thought we had enough time.
Let's talk about what you stand to lose. You're where the defendant in this case is Dragon Studios.
That's correct. That's my studio.
You own it,
Yes,
founded it,
I did.
president of the defendant.
I am the president.
You own 100% of it.
I do.
Let's talk about that original plan for the stunt. Approaching the witness with what's already in evidence as Exhibit 34.
I'll remind the parties and counsel to ask for permission and wait
Oh.
for the court to.
Excuse me, may we approach?
You may.
Now, this is the original plan that y'all drew up for that stunt.
This is correct.
The terms to make sure it'd be safe.
That's correct.
This is what y'all did all of those training hours for in preparation for this plan.
Yes, for Peter to go off the side of the mountain.
The day you did all 6 successfully, this plan was used.
That's right.
Says your company would be responsible for telling the performer when to open the parachute.
That's correct.
Says it would be 4 seconds after the motorcycle leaves the ramp.
That was the plan for June 20th, and then we agreed to something different for June 21st. That's correct.
Let's talk about that. Because you just used the words, we agreed. That change, that was your idea.
Sure, it was my idea, but like I said, we agreed to it.
It was your idea to have the plaintiff wait longer before pulling the chute.
That's correct.
The plaintiff only agreed after you said, don't worry, stunt coordinator says it's fine.
That's right.
Let's talk about why you would want to change that plan. Because you reviewed the footage from the first plan, right?
Yes, I did.
Thought it wasn't good enough.
I thought it could be better. Yes, that's correct.
Shot wasn't long enough.
That's right.
Thought it was not impressive,
Not for what Peter had done in the past, no.
incomplete.
Didn't look as good as it could be. That's right.
You thought your audience would want more.
Yes, that's correct.
You thought you needed to push it further. Isn't that right?
I thought we could get a longer shot.
Nothing further.
Thank you. Any redirect?
Yes, Your Honor. Ms. Droig, a few moments ago, you were asked about what you had to lose in this trial. I want to be clear, did you have financial interest involved in the success of that stunt on June 21st?
I did. We were in the 7th franchise movie with Peter, and we planned to go even further if we could.
You were also asked about the earpiece working during practice stunts. I want to be here, during those practice stunts, was Mr. Jones jumping off of a mountain?
No, only on June 20th and June 21st did he ever launch off the mountain.
Thank you. Your Honor, I have no further questions.
Thank you. May this witness be excused?
Nothing further from us. Nothing from us.
Thank you, Ms. Dory. You can step down.
If we could just use the remainder of our cross time to read portions of depositions from unavailable witnesses.
Let me ask counsel how the defense feels about that.
Your Honor, we have no objection to them reading the depositions. We may have objections to the actual content of the documents they're reading out of the record.
I think the court has concern about why this wasn't done during plaintiff's case in chief.
In all honesty, we didn't have time, Your Honor. But
Okay.
we like to use our cross time to do it.
I think the court's going to deny that motion.
Yes, Your Honor.
Any further evidence from the defense?
No, the defense rests.
Okay, great. Thank you. Why don't the parties take a minute to gather their thoughts before closing argument?
Yes, Your Honor.
When you're ready, counsel, give me the thumbs up and get started.
That's good.
ready to go, Your Honor.
Great, thank you. Since you're first, you can go ahead.
Okay, please, court. The original plan was dangerous. The defendant's plan was dead. Just about every witness agreed on all the important facts in this case. Both witnesses agreed. Original plan, pretty dangerous. Both witnesses agreed. That change, even more dangerous. And both witnesses agreed. The producer wasn't honest. Now, she didn't want to admit it on the stand at first. But then we asked the producer about what happened during that deposition. He said, I don't remember. Yeah. What did you actually say? I wanted a longer shot. That's the problem, members of the jury. You can't put your performer's livelihood at risk for a little bit of an audience boost. The first 6 times they did that stunt, no problems. The first time they used the defendant's plan, Peter Jones died. And members of the jury, we did have the burden of proof in this case. We had to prove, more likely than not, that the defendant acted negligent, and that their negligent actions caused Peter Jones to die. We proved that to you today. But before we talk about how we proved our case, let's just talk about the defenses for a moment. Because they want you to believe that out of nowhere, for no reason whatsoever, this earpiece just went kaput. We know that doesn't make sense. Because you heard they did hundreds of practice runs with not just any earpiece, not just an earpiece you could get at Walmart. They did it with this earpiece. And how'd it go? Without a hitch. We know it was working because the day prior, they used this exact earpiece and there were no problems whatsoever. Let's assume just for a moment that the earpiece did malfunction. They'd still be responsible. Because whose job is it to make sure that the equipment is safe? It's their job. They supplied the earpiece. At the very least, they should have tested it to make sure that it would be safe when it mattered most. Even if it didn't work, they're still lying. So let's talk about how we proved our case. The first fact. The producer made her own plan. Because she's looking at the film from that first stunt. She pulled off the most daring stunt in cinema history. Most people would say, yeah, this looks pretty great. The defendant says, not good enough. Let's do it again. Everyone agrees. That change made an already very dangerous stunt even more dangerous. So the question becomes, did the defendant give that signal to pull the parachute? Let's compare who you should believe. That's fact number 2. The producer wasn't honest. On one hand, you have Eli Godia. No reason to lie. Credibility wasn't even challenged. Nothing to gain from the result of this trial. Eli says, no signal given. On the other side, you have the defendant. The defendant's producer owns the defendant, 100% of it, president of the defendant, founder of the defendant, stands to lose a whole lot, and we know what her word is worth because you heard today she admitted on the stand she wasn't truthful. She hid what she actually said at that scene from her attorneys. If she lied then, what's to say she's not? She's lying now. That brings us to fact number 3. That plan caused Peter Jones's death. Because in that moment, Peter Jones is falling from the sky. Earpiece in. The same earpiece that's worked hundreds of times before. And he's waiting. When am I going to hear it? Pull the chute. Now's the time. He doesn't hear it. The defendant's producer never gives the signal that she promised to give. Because of that, now Peter Jones is reduced to a picture in his sleep, only being referred to in past tense. He trusted the producer. He trusted the producer when she promised, I will give you that signal, but that producer took that trust, threw it out the window, took that trust, and broke it. The original plan was dangerous. The defendant's plan was deadly. Fine in line. Thank you.
Thank you, counsel. Closing argument from the defense.
Yes, Your Honor. The question becomes, did the producer give that signal? That's what plaintiff counsel said to you just a few moments ago, and we agree. That is what this case comes down to. It's a little bit more complicated than that. Because today it wasn't just whether or not they gave this signal. No, today they have to prove that Ms. Doig did not give that signal. Prove that that earpiece actually worked and that Ms. Doig just chose not to try and protect her own employee. But they haven't been able to prove that today. They haven't come close. And to help you see that, I want to go back to those same three questions we asked you to keep in mind at the beginning of this trial. So first, what is the plaintiff asking you to believe? Well, today they've said it over and over and over again. Their case comes down to three simple facts. First, the producer made a new plan. Now, we agree. Ms. Doig sat right there. She told you, yes, I made a new plan. Yes, I wanted to do something different. Yes, I wanted to get a new shot. I mean, plaintiff counsel can stand up here and say it in a menacing voice as much as they want, that she said she wanted a longer take. That doesn't mean that she's negligent. It doesn't mean that she caused Mr. Jones' death, and it certainly doesn't mean that they've met their burden. Because remember, she was the director, the producer of this film. It was her job to try to be creative. She hired experts to look at her plans to make sure that they worked. And she told you that's exactly what she did. She told you that she hired a stunt crew, that she had them oversee everything, that she asked them, this plan that I'm proposing, is it safe? And they told them yes. That is undisputed evidence in this case. Think about that. The only thing we've heard about a safety coordinator, an expert, anything in this case, came from Ms. Doig herself. Not from the plaintiff, not from the party with the burden, but from her. And so then we get to the second fact. Well, she wasn't honest about that plan. The problem is those first two facts are inconsistent. Because on the one hand, they want you to believe, oh, she was this manipulative mastermind who was in control, who pressured Mr. Jones to do this deadly stunt that she knew could kill him. So she had all this power. She was calling all these shots. She was ignoring these experts. Why would she make a plan that she knew the next day she wasn't even going to follow? That just doesn't make any sense. If she wanted him to wait 10, 15 seconds, whatever they're saying she was, which frankly isn't really clear what they're saying she actually wanted that day, well, then why didn't she just make that the plan? It doesn't make sense. Because it doesn't make sense for her to have sit there watching him fall. They're asking you to believe that Ms. Doig, who had put millions of dollars in resources, hired a crew, built a house in Notre, built a ramp, consulted stunt experts, just decided to throw that all away because she didn't want to be honest to people, that just doesn't make any sense. And the story they're telling you, it doesn't line up. So then they say that third fact, well, her action, her failure to send that signal, that is what caused Mr. Jones' death. But that's when you have to remember that they have the burden of proof in this case. And so when the key fact, the key question in this case, the fact that proves causation comes down to a he said, she said, well, that's just not enough to prove their case by a preponderance of the evidence. Which brings us to our second question, well, how much evidence do they really have? Today they only called one witness. He told you what he saw, what he remembered from over a year ago. But you heard Ms. Boyd tell you that that's not what happened. Now, sure, plaintiff counsel can stand up here and wave this earpiece around, say that it had worked in the past, but remember, this was a whole different ballgame. They were jumping off a mountain, riding on a motorcycle. It was loud, there was wind, they were falling fast. Don't you think it's possible that at some point this earpiece could have cut out? Malfunction? Is it possible that maybe it was working, but he just didn't hear? We don't know. Because they didn't actually bring you any evidence looking into it. They didn't call a single expert witness who confirmed that this was working. They didn't talk about any tests that were run after the fact. I mean, you can see it yourself when you go back to deliberate. It's just a regular earpiece. Is it possible there was something wrong with it? Something that the stunt coordinators missed? We don't know. And it's just not enough to meet their burden. That brings us to our third and final question. What actually happened on the day of Mr. Jones' death? The day Ms. Doyle told you she tried again and again and again to send that signal, yelling, screaming, pull that cord. But that he didn't. She told you that she doesn't know what happened. She doesn't know why he didn't do it. But it wasn't our burden to prove. It was their job to prove that her actions were the actual cause of Mr. Jones' death. And they haven't done that. Because today, you saw that it just didn't make sense for her to have ignored those risks. You heard how invested herself and her company were in that stunt. And it just is not more likely than not that she would just sit there, watching him fall, doing nothing when the day before she had agreed to a plan, made a plan to do differently. They haven't met their burden. It's why we ask that you find the defendant company not liable. Thank you.
Thank you, counsel.
Can I get a time check for rebuttal?
Sure thing.
1 minute and 17 seconds.
I have one.
All right, what was the discrepancy?
It was a 17-second discrepancy.
We're fine with you just taking a minute 17.
Thank you. Appreciate it. No problem.
Whenever you're ready, counsel.
Police court. Opposing counsel didn't even try to respond to the argument we brought up on closing argument. The defendant is responsible for making sure the defendant's equipment works. Let me say that again. The defendant is responsible for making sure the defendant's equipment works, even if they're right. It's unlikely they are, but even if they are, they're liable. What's more likely? The one day the defendant decides, let's change things up. Let's go with a more dangerous plan. Let's do something we've never done before. Let's deviate from the months of training, planning, practice, throw out the window. Let's go 9 seconds. That's what I'll tell everyone. Isn't honest about what she said. And eyewitnesses say she didn't give the signal at all. That's the first time something goes wrong. That is negligence. The original plan was dangerous. When she made that choice, her plan became deadly. Find the defendant liable. Thank you.
Thank you, counsel. Okay, the case is submitted to the jury, why don't we give our jurors a moment here to submit their ballots? I'll do the same.